who wants to start the tutorial off?
Okay, I'll get things rolling.
Good man.
Just a few queries about the group discussion assignment. I think it's fair to say this is something new to probably nearly all of us. And getting your head round it, it's taking quite a bit of doing and quite a bit of work. And I know a lot of people have been putting information and cases up and chit-chat either side, but it is a little difficult to see if we're on the right track.
Well, as I said in the email I think I sent out yesterday, there's a bit of variety in the quality of the postings so far, but there are definitely people who are on the right track. There has been identified by Tara a decision of involving the Essendon Football Club and Asada case, and Tara has noted that it's gone on appeal, which everybody will have seen in the media, I hope, and that's certainly the sort of posting in terms of media commentary that is relevant to the discussion forum. There's been a question posted by Joel and Lester about whether or not you can discuss that because it's part of your assessment. Your assessment is actually relates to the first instance decision of Justice Middleton rather than the appeal case. So there's absolutely no problem discussing the fact that an appeal has been lodged. Some of the other postings that are very good, Jolan's noted the decision of Recca and the President of the New South Wales Anti-Discrimination Board, which obviously started as an administrative determination of sorts and then found its way to the Court of Appeal in New South Wales, which is part of the Supreme Court. That's also very relevant. There's also been a big case that's been getting a lot of media attention in New South Wales this week, involving the Deputy Senior Crown Prosecutor here, Margaret Cunneen, and the Independent Commission Against Corruption. And everybody will recall that I discussed the ICAC and the other similar sorts of bodies in other states last week, and the case that's in fact was in the Supreme Court this afternoon is certainly an administrative appeals decision by nature of judicial review, and comparable in many respects to the Asada decision in the sense that it deals with the exercise of power by regulatory authorities and attempts to restrain those sorts of cases. There's been some talk about a decision, Robin, you can jump in here when you're ready, regarding the Administrative Decisions Tribunal. The Administrative Appeals Tribunal, an appeal panel. And that might be a good place for us to start this evening in terms of the nature of the jurisdiction that case involves. Do you want to jump in, Robin?
Yeah, thanks, Brett. I'll just give a bit of a summary of the case just for those people that haven't yet read it, if that's all right.
Yeah, certainly.
So it was Holly and Everett. It was actually decided on the 29th of October, so it's very, very recent. Everett is the owner of a website, and she made an oral contract with Holly to design that website. Evatt believed that Holly didn't fulfil her obligations in that contract and made a claim under the Consumer Claims Act, and that claim was heard by the New South Wales Civil and Administrative Tribunal, so NCAT. The tribunal found in favour of the web designer, and the owner, Evatt, made an application for appeal to the same tribunal. Her appeal was based on her belief that the tribunal's conclusion was one, the conclusion was against the weight of evidence, which I actually don't understand what that means, and secondly, that the tribunal had no opportunity to hear her side of the story. So she actually believed that the tribunal didn't follow correct procedure. In the end, the appeal was granted. And I've got two questions relating to this, and I really struggled with understanding what was happening here. So my first question was, why would Evatt apply for an appeal rather than an administrative review? And my second question was, it appears that the tribunal actually undertook a judicial style review during the appeal determination. And I think John Topless actually commented, sorry John, I can't remember what you said about this, but I'm just wanting to seek some clarification around all of this, if you could help me with that, Brett, or anyone else.
Well, what does everybody think before we get started? Well, before I jump in.
I can't actually remember what I said.
So, well, let's break it down. This is a decision, and Robin has posted the PDF of the decision in the assessment forum for everybody who hasn't yet had an opportunity to look at it. You can go in now and actually click on the PDF, and it's there for everybody to look at. So anyone who doesn't have it in front of them might want to do that before I get into the detail of the case. But you'll remember from last week, one of the things we were discussing was the creation of these administrative dispute resolution bodies, and they're known variously as VCAT, NCAT, QCAT in Victoria, New South Wales and Queensland respectively. These are administrative bodies which function very much like courts. I mean, they're designed to be less formal than courts, and they're designed to give people who might find the cost of litigating a dispute a more cost-effective option. And in this particular case, as Robin said, it was a dispute in the commercial or consumer division. So the applicant filed a, you'll see the procedural history set out in the early parts of the decision, but the long and short of it is that an application was filed in relation to an oral contract, and I don't know where you're up to. I suspect a lot of you haven't done contracts yet, but in summary, so far as you need to know for the purposes of this discussion, you can form a contracts don't have to be in writing. Anytime you reach an agreement which is certain and involves consideration by each of the parties, you can form a contract, and it doesn't need to be in writing. The exception to that, the well-known exception to that, is contracts which are for the sale of property, but that's only because the conveyancing acts of the respective states mandate that it has to be in writing, as does in fact the Real Property Act in New South Wales. In any event, the parties formed a contract, and there was a dispute about the contract which they took to the New South Wales Administrative Civil and Administrative Tribunal. Now, the tribunal member at first instance Mr. Vrabak, who is a senior member, and incidentally I used to handle all the appeals of this kind from this particular tribunal much earlier in my legal career, and Nick Vrabak was in fact one of my bosses. But he made a decision in the matter, and the applicant was not pleased with the outcome, in the sense that, so far as the applicant was concerned, the decision that the senior member reached was wrong for a number of reasons, and the relevant consideration here was the fact that it was against the weight of the evidence, so to speak. Now, Robin says she's not quite sure what that means, and that's because we haven't covered it in this course as yet, but you'll see if you've got your textbooks in front of you that in chapter 8, I think it is, hold on a second. Sorry, I beg your pardon. Chapter 12, which I think correlates perhaps with week 8, we deal with law, fact and evidence, and the way that administrative decision makers have to apply the law to the facts as found and the relationship between the facts and the evidence. And this is the sort of case which turns on that, so don't be concerned if you don't quite understand that as yet. It's much too early for you to be understanding exactly how facts and evidence interplay with administrative law. But the long and short of it is that in this particular case, one of the parties was dissatisfied with the way that the tribunal member at first instance resolved the question or the matter of dispute, and sought to take it to the appeal panel. Now, so far as the content of this week's program is concerned, one of the things that, well, the primary matter that this case is relevant to is the question of whether it's judicial review. Does anybody want to make some comment about whether the case that Robin has posted, that is the 2014 New South Wales Civil and Administrative Tribunal Appeals Panel, is judicial review or merits review?
Would it be a judicial review?
Why would it be judicial review?
Well, I don't know, but we have QCAT in Queensland, and then that's a member or a magistrate or something that sits on those that make that decision. So it's not, he doesn't, I suppose they weigh up the evidence, and it's a,
is everybody with us? I think, Robin, you've dropped off there.
Whoever's got this, whichever way they believe with the strongest evidence, but I thought it might be in judicial because it's a member or magistrate or whatever you want to call it that sits.
Okay, who else has got a view about whether it's judicial review or merits review?
I think that the main differences between the two is that with a judicial review, the only outcome
Oh, sorry.
if they
Is that right?
if the goes against, then they cannot change any of the outcomes. It just is, the decision is reversed, and it has to go back then to the lower presiding authority, whereas with a merits review they can actually make a different determination.
That's an important consideration. So are you contending it's judicial review or merits review, John?
I have to say I wasn't entirely sure in my own mind which one it fell into. It almost seemed to fall between the two, but obviously it couldn't. So I'll go for judicial review.
Who else has got a view?
It's Robin here. Can you hear me?
I can.
Okay. I originally thought it was a merits review. But the only reason that I thought it was merits review was because I understand that a tribunal can't undertake a judicial review. But then when I read it, I kept thinking it appears as though it is about procedure. And so then I kept swapping between judicial review and merits review.
And where did you end up?
I've ended up in the same place I started. I don't know. I don't know the answer.
Anyone else?
I guess. Sorry, Brett.
Yeah.
The first question that I actually had was I just couldn't understand why she wasn't applying for a judicial review. Why she was applying for an appeal as opposed to a judicial review. Yeah, so there was a bit of confusion there as well for me.
Well, that's a good question. Judicial review, you'll recall, is about whether or not typically an administrative or executive agency has followed the correct process and or acted within the scope of their power. In this particular case, is there any, and so let me go back a step. You'll also remember that when I spoke to you in the very first part of the session, that I just suggested that understanding administrative law is also about understanding not only what it is, but what it isn't. And that the true can be said not only for understanding administrative law generally, but also understanding the subspecies of administrative law, be it judicial review or merits review. Now, in this particular case, you've got an administrative appeal, or sorry, an administrative decisions tribunal making a decision which one of the parties says is wrongly decided. Pausing there for a moment, if the argument is that it's been wrongly decided, is it more likely to be merits review or judicial review?
Would it be a judicial review then?
Mm-hmm. I think two people spoke there. I think you cut across each other.
Merits review.
Sarah says merits review.
I think the point about being a judicial review is it has to be decided on whether or not there was a point of law that was at issue, and whether or not it's actually the case is judiciable.
Mm. Now, the answer to Robin's question is complex, which is why I didn't want to jump in straight away and give it to you. I think it's helpful for you to have a discussion about the principles which inform how you would reconcile this question on your own. But in truth, the decision, this particular decision, the appeals panel decision, is neither merits review nor judicial review. It's an appeal. So, by way of an example, if for example this had been a simple contract dispute and it didn't have a consumer element to it, it wouldn't have been within the jurisdiction of NCAT. It would have been a matter which had to be determined in the courts proper, if you like. So in New South Wales we have the local court, the district court and the Supreme Court. Disputes up to $150,000 can be litigated in the local court. Disputes up to $750,000 can be litigated in the district court, and anything over $750,000 goes to the Supreme Court. If a person was not thought that, for instance, if the dispute was over $50,000, it would go to the local court, and let's assume for a moment that this dispute is worth $50,000 and it was started in the local court. If one of the parties, after hearing the court's determination, was of the view that the magistrate had wrongly decided the case because they applied the wrong section of of the contract. Let's say they applied or considered the wrong provision of the contract. They would lodge an appeal to a higher court in the hierarchy. In this case, the Supreme Court is where you take an appeal from a magistrate to on a civil dispute. And you would go to the Supreme Court and you would say, the first court to consider it got it wrong because they applied the wrong provision, and the matter needs to be determined in accordance with the provision that applies to this particular dispute, and you would ask the Supreme Court to then remit it back to the local court. That's not a process of judicial review or merits review. It's what's called just simply an appeal. Now, the same sort of procedure is laid down for a lot of administrative tribunals. So the first instance member, senior member Vrabak, was asked to determine a question, the particulars of which are not particularly important, but which was a dispute between the parties. The Enabling Act that allows the senior member to effectively arbitrate that dispute also provides for a process of review. That process of review is an appeal, which is why an appeals panel is assigned to the case. So one of the ways that you might resolve the question of what sort of jurisdiction the appeals panel was exercising is to go to the ultimate relief. And you'll see at paragraph 52 of this particular decision that the appeal panel made an order granting leave to appeal and then allowing the appeal, setting aside some of the orders made by the senior member, and then remitting it back to the senior member to decide how the dispute should be resolved, having regard to the directions which are made in the earlier part of the decision. If the tribunal were if the appeals panel were exercising the power of judicial review, what you would more likely see as the form of orders in paragraph 52 is an order granting certiorari, which is just a Latin term for uplifting the record, and we'll cover that in more detail as we move through the course. You would see an order quashing the decision which had been made by the tribunal member, and probably not making very much more by way of orders other than an order for costs if costs were sought. By contrast, if it were the case that the appeals panel were exercising a power of merits review, what you would see is a wholly new decision reached, or a wholly new outcome reached by the reviewing panel. Now, the clues in this particular case as to the nature of the jurisdiction can be found in paragraph 52, in the sense that you'll find nothing there that quashes any purported exercise of jurisdiction. And quashing is very different to setting aside. The word setting aside is the sort of language that you expect to find where it's an appeal as distinct from judicial review or merits review. And you only find those words set aside where the appellant has been wholly or partially successful. Is everybody following me so far? It's sort of the long way around, but I'm trying to break it down for you so that you can get the sense of how an appeal is different to judicial review and merits review. Any questions arising from that so far?
Brett, Paul Alcorn here. I've just got a question reading these orders from this. Sorry, can you hear me? Hello?
Yeah, you're sort of coming in a bit patchy. Can you hear us? Hello? Can everybody hear me? Is it Paul's connection or is it my connection?
No, you're coming through loud and clear, Brett.
We still got Paul? Are you still there? Okay, looks like we've lost Paul. Does anyone else have a question arising from the explanation I've just given about why the decision that Robin's identified is neither judicial review nor merits review, but falls into this separate category of an appeal in the general sense? Gordon, you're asking, what does 52, when there's a basketball, I think it is, remit the matter to the tribunal, indicate? I have to say I'm not quite up to speed on the emoticons. I'm not sure what the basketball means, but if the question is, what does the order number 3 in paragraph 52 thank you, mean? It is an order effectively sending it back to the tribunal member, that is senior member of RABAC, or the words similarly constituted, just to indicate that a different member could also hear it if the logistics of the tribunal require it. But remitting the matter simply just means, well, let's move through the orders. So the appeal panel says they grant leave to appeal, and whenever you see leave to appeal being granted, it simply means that appeal is not available as of right, that you have to seek leave, and that can be for a number of different reasons which are not relevant to tonight's discussion, so I'll move on. So they grant leave to appeal, and then they allow the substantive appeal. The next order is that having allowing the appeal, that is the appeal being successful, orders 1 and 2, which were made by senior member of RABAC on the 3rd of March, are set aside. That basically means that they're of no effect until the dispute is redetermined. And then the next order, which is really consequential or procedural in nature, is to send the matter back to the tribunal to correctly decide it. Now, in that sense, this particular appeal is closer to judicial review than merits review. That is because the appeals panel was not free to just simply re-decide the case, but it's not technically judicial review. I hope that's answered the question. Who else is?
Brett, it's Robin
Just
again.
forgive me if I... Yeah, go on, Robin.
So, I guess my bottom line question is, why would this case have sat in the category of administrative law? It came up on a LexisNexis report that I had access to as an administrative law case.
Yeah.
Why is it categorised as administrative law?
Who can answer that question or hazard a guess?
Would that be because it's an individual against a government department?
Well, in this case, it's actually 2 individuals, isn't it? Anyone?
I'll hazard a guess. Is it because the tribunal made a decision on the Holly v. Everett, and then the appeal is against that decision? So it's administrative because it's a appeal against an administrative or a governmental decision.
That's what I was thinking.
Yeah, look, they're not bad efforts at it. Let's go back to first principles. How many branches of government are there?
3.
Yep. Is the NCAT, well, the 3 branches of government, as you know, the Parliament, the Judiciary, and the Executive. Is NCAT part of the parliamentary branch of government? Anyone say yes? Yeah, it's not, obviously. Is it part of the judicial branch of government? Kylie says no. Why not? Why is NCAT not part of the judicial branch?
It's tribunal.
Is it a court? There you go, Ray. It's not a court. Is the simple answer. Although it works very much like a court, it is a tribunal. And that's right. Dean points out it's not a Chapter 3 court, or which is technically part of because it's part of the state. It's not a Chapter 3 court, and it's not a court which exercises federal jurisdiction. Unlike, for example, the Supreme Courts of the various states, which in some cases can be vested with Commonwealth jurisdiction, a matter that you'll come to in constitutional law in due course. So it being not a proper court in the sense that it's not part of the magistrates court, the district or county court, or the Supreme Courts, it is a species of executive government, and it's a tribunal that is set up to try and give the citizenry of New South Wales a cost-effective option for resolving their disputes. So that in mind, why would it be considered by the LexisNexis reports as an administrative law case? Hopefully I've given away the answer. Robin, jump in here. Has that helped?
Yeah, basically because it's a question regarding the executive, the decision made by the executive. So that's why it's administrative law.
Yeah. So it's not that's sort of getting close to the reality of the circumstance, I think, in the sense that I think what you mean, Robin, is that it is a body that's established by Parliament as an administrative body to resolve disputes. It's not a court that's been established, and so it would therefore come within the definition of the executive branch of government. And that's probably why when you do a search it's come up as a administrative law case. So unless there's anything particular about this particular decision, why don't we try and move on to cover something else, because we're about halfway through this tutorial now. Hopefully that's resolved the question, and if not, there is already a thread on the forum dealing with this particular case, and hopefully after the little discussion we've had here, you guys can all make a contribution towards resolving that very good question which has been posed. Is there another example or some other issue we can move on to? Anybody got a burning question?
Yeah, I have, Brett.
Yep, go on, Anthony.
When you look at these things, when you look at these cases, what's the first thing you look at? Is it the orders?
Look, it depends on it. If you're asking when I read them, what is the first thing I look at? There's unfortunately not one correct answer. It really depends a lot of the time on why I'm reading them and what I'm after. But if I were seeking to identify the nature of the jurisdiction, I would probably start by reading the first probably 9 paragraphs of this decision. Then I would probably go to the latter part of the decision to have a look at the nature of the orders which were made, because they're usually a pretty good clue as to the nature of the jurisdiction, as I indicated a bit earlier. But probably the best way to answer it, if this were a truly administrative law case, one of the first things that you'd be looking at would be the nature of the orders which were sought. So if we contemplate a hypothetical for a moment, assuming that this Holly and Everett decision was resolved in such a way as to, let's say that the tribunal member at first instance had made orders rather than, you'll see in paragraph 4, the order that was given was that the respondent was to reimburse the applicant for the sum of $990. If the tribunal member had made an order, for instance, that the respondent was to take some affirmative action, such as specific performance. Hopefully you've covered that in contract law for those of you who I understand are already studying it. If the direction was to specifically perform the contract, and that was not a power that the tribunal member had, then you might have expected this to become a case of judicial review, in the sense that the respondent would go to the Supreme Court of New South Wales and say, hey, this tribunal member has just made an order against me which he's not empowered to make, and I want relief from it. Now, how that would be framed in a judicial review context here, and what I would be looking for fairly early in the decision, would be some indication in that the pleadings, those are the documents which kicked off the case, make a reference to a request for an order of certiorari, uplifting the record from NCAT to the Supreme Court, an order of prohibition, which is a type of relief which orders an administrative officer, a member of the executive government, not to engage in certain conduct. And probably, so the orders you'd be looking for would be, or the paragraphs of this decision you'd be looking for would be something that suggested that the appellant, or the applicant, in New South Wales called the plaintiff, was seeking an order for certiorari, uplifting the record, an order quashing the decision of the tribunal member, an order prohibiting the tribunal member from making orders in the nature of specific performance, or orders of that effect. That would be the first clue to it being a type of judicial review decision. Does that help?
Yes, it does. Thanks.
Okay. Who else has got something to raise?
Brett, looking at the problems that were set this week, I seem to get the idea that most of them were involving some degree of whether or not these situations were judiciable or not.
Were justiciable?
Yeah, whether they were or whether they weren't. I thought that seemed to be the main thread running through them. I'm just wondering whether or not I was on the right track there.
Well, I think you are. I've read your posting in relation to problem 6, John, and I think the questions there that you've raised and the answers that you're flagging are good starting points. I know that there's some other postings in relation to problem 6 that you're all sort of attempting to make well, not all of you, but certainly some of you are trying to make a contribution towards resolving it. But effectively, the problem question in 6 requires you to work through. It tells you that recourse to the Administrative Appeals Tribunal is not available. So straight away you know that this is not a case involving merits review. So what a good answer to problem number 6 asks you then really to go through the elements which would be required in order to get this into a court where you could conduct or seek judicial review. So certainly justiciability is one of them, but it's not the only one. Who can flag some other issues which arise in these sorts of questions, or in problem 6 in particular? I'm sure, Anthony, you'll have something on this, I think, from your emails. Anyone? Colin says legal standing. That's so standing certainly. Is there anybody who doubts that Sharon would have standing? I mean, it's a decision that affects her, which you'll recall is the essence of standing. What's the next consideration? Jolan says a ground for review. Is there a ground for review here, anybody? Don't be shy.
Yeah, I thought on this part that she was on a bit of thin ice, because I didn't think that it was a legal problem. It's more of an unreasonableness problem.
Mm-hmm. And what do we know about unreasonableness in a very limited sense at this stage of the course? Can unreasonableness be a grounds for judicial review?
No, this is really where it goes over to merits review rather than judicial.
Well, yeah, it's where reasonableness is certainly where it starts to straddle the divide. And you recall that I mentioned in the introductory seminar Wensbury unreasonableness. Does everybody know what Wensbury unreasonableness is?
Yeah.
It's that doctrine which goes very close to sort of being merits review in the sense that it arises, that's right, as Ray says, where no reasonable person could have come to the decision. So this particular problem question is sort of raising that as a ground, but given the stage of the course that you're at, I wouldn't expect, at least at this stage, for you to deal in any great detail with unreasonableness, but certainly to be able to identify the necessity to argue a ground when you go to a Supreme Court or the Federal Court arguing that you should have relief by way of judicial review. An answer to problem question number 6, I certainly think needs to deal with firstly standing and well, go back a step. Even before standing, what have you got to have? Exactly, a decision. Jurisdiction comes next. You've got to have a decision, as Kylie points out. And what sort of decision have you got to have? Yeah, well, a decision of an administrative nature or an administrative character. Gordon's hit the nail on the head there, and I've already, for those of you who haven't already had a look at his post under problem 6, it's a very good example of the sorts of preliminary considerations that you need to have in mind whenever you think you've got a problem involving judicial review. The first, of course, is a decision that's of an administrative nature, and one which is justiciable, or what in statutory language is often described as a decision that's not been excluded. So you'll recall last week I talked about the process for applying for Social Security and certain administrative requirements or decisions being made along the way of having to lodge an application in order to be considered. The requirement to lodge an application is probably not justiciable, but in this particular case the scenario has gone much further than that, and it said that a application was lodged, but that it was deficient in some respects. Now, one of the sorry, just to read Peter's comment. I mean, Peter's picked up on the technical language which is used in the text in particular about it being a final, determinative, substantive or operative decision rather than one that simply is procedural in nature. And what you've got in problem, which is a very good observation, very helpful, what you've got in problem number 6 are a number of decisions along the way. So you've got the facts say that an application is made on the 18th of June. The scenario doesn't say whether or not an application was lodged, but what you would probably do in question 6 is say something to the effect of, I am assuming for the purposes of this particular question that applied for a license on 18 June is a reference to the applicant having lodged an application. Then what you've got is a series of administrative requirements or administrative directions about further documents being provided. Ultimately then what you have is a determination, and this is to be found in the 3rd paragraph, and I'll just read it out. She, being a reference to Sharon, returned the next day on 1 July to submit the necessary documents. But the ADSS refused to accept her application because it had been submitted after the deadline. Now, I think one of the things that can be argued in this particular case is that Sharon's application had been lodged on the 18th of June, and that a series of administrative requests were made thereafter for supplementary information. Now, if that is the correct characterization of what's happened here, that is that on the 18th of June an application has been submitted, then the determination made on the 1st of July that an application had not been submitted is potentially an error. That is, if the application had been lodged on the 18th of June and that all you had then was a series of requests for supplementary information, for an administrative officer, an agency of executive government, to then conclude that an application has not been lodged within time is quite possibly wrong. If it is wrong, it is perhaps wrong because it misapprehends the nature of lodging an application, which is, of course, what we would say if we were representing Sharon, what occurred on the 18th of June. Is everybody with me so far about how you might argue or advise that this is a the sort of problem which attracts judicial review. Excellent. Anybody know? Anybody got any questions with where I've gone with that so far? Because if not, what I'll say is that if you were Sharon's lawyer and she came to you with this problem, I suspect that what you'd be saying is the executive got this decision wrong, or the administrator got this decision wrong because they misapprehended the test in the Disability Support Workers Act for the lodging of an application. That the lodging of an application on these facts occurred well before the limitation expired, and that in refusing to then process the application because supplementary documents were received at some time after the 1st of July, what you've got is a failure by the executive to properly exercise the jurisdiction, or a failure by the executive to properly interpret and apply the relevant statute. And Gordon points out that it comes close to statutory interpretation, and administrative law quite often is fundamentally, at least in the early stages, a question of statutory interpretation. What is the requirement? Is a process of interpreting a statute ordinarily, particularly in the federal context with which a lot of you, well, this course is primarily concerned. Then flowing from that are questions of whether or not the facts with which an administrative officer is presented answers that test. So the administrative officer has got to firstly characterize the question, and they have to do that correctly, and then they have to apply the facts that they've got to that question. And that particular process, if not done correctly, can arguably provide a very solid basis for seeking judicial review. Anyone got any questions about problem 6? Anyone got any other questions? Otherwise, what I might do is, if you want to, move on to another problem. Anyone want to raise another question arising from the readings, or anyone want to direct attention to a specific problem question? Yes, Peter, the question there Peter's raised is it a case of legal error? The argument I would be prosecuting for Sharon if she were my client is, yes, it is a case of legal error. The administrative officer has misunderstood the requirements of lodging an application, and has falsely or erroneously concluded that the application was lodged out of time, when in fact it was lodged well within time. To be aggrieved, does that mean you have to be worse off or just affected? That's a very interesting question, and it's not one that has an absolute answer. Sorry, who's answered that question? Kylie? Ordinarily, well, the threshold question really is just, are you affected by the decision? I use the word aggrieved quite often because it's sort of a mental cue to me that you often want to have something than simply being affected by a decision, because decisions of government are made all day, every day, which affect me, but which don't necessarily aggrieve me in the sense that they don't make me worse off. And if that's the case, it would probably be unlikely that you would get the sort of discretionary relief that is often involved in a petition for judicial review. That's right, Peter. Effectively, your rights do have to be altered, but there usually has to be a bit more than that. For instance, my rights, and rights is probably the wrong word in the sense that it is an area of jurisprudence which is been the subject of many, many texts about what exactly is a right. But assuming for a moment that I am eligible for a certain benefit, and the law provides that the minister can adjust entitlements for that particular benefit at their discretion, subject to a review process. The fact that my benefits have been altered, as have the benefits for an entire class of people, doesn't necessarily make me eligible or provide me with standing to seek judicial review. There would have to be something more significant in the sense of there being some error in the process by which my benefit or my entitlement was calculated or arrived at. I don't want you to get too bogged down in the distinction between alteration and grievance, because at the undergraduate level, I'm not expecting you to have very much more knowledge than simply I'm not entitled to seek review for something that doesn't affect me in a real sense. Gordon wants to go to question 7. So let's all pull that up. If everybody's read that, Gordon's question is this a matter of an excluded type of decision? And secondly, does the consortium actually have, are they actually affected by this dispute? Or I think what you're asking, Gordon, is would they have standing, correct? Who has got some thoughts about problem question number 7? Why are they not a party to the dispute, Anthony? Or anybody else for that matter?
It's Robin.
Yep.
My answer to that was around the fact that Schedule 1 of the ADJRA excluded the decisions made by the Minister for Immigration and Border Protection under the Migration Act, and that there were subsections in Schedule 1 relating to privative clause decisions.
Yep.
And so I said that the consortium would have no grounds to apply for a judicial review of the Minister's decision. And
that was an excellent contribution, if you don't mind me saying so, Robin, in the sense that you've clearly done some relevant research into the nature of the Minister's decision making and the extent to which it's reviewable. Let me ask you this, everybody, though. Is the decision not to release a report a decision that's made under an act? Or is it a decision or even perhaps an absence of decision of a purely ministerial and administrative nature? Is there anything in the, and I guess what I'm asking in more detail, is there anything in the Migration Act or any of the related legislation, actually it's not complicated, is there anything in the Migration Act which talks about when a minister is required to release reports or information?
Well, it's Robin again, Brett. I looked specifically for that and I couldn't find anything, but I did find a clause that said that Section 474(3)(g of the Migration Act, and it related to a minister doing or refusing to do any other act or thing, and that action could not be taken against them for doing or refusing to do any other act or thing, and that was the basis of my decision.
And to that extent, I think it's an excellent answer, Robin. I think you've done. If this were a question which clearly involved a decision made by a minister of a kind which the Migration Act requires them to make, you will have hit the nail on the head. What I'm asking though is this the sort of decision which, that is a decision to release a report, is that the sort of decision that the minister is required to make under the Act or empowered to make under the Migration Act? Or is it a sort of tangential decision that is made?
I thought there might have been a bit of prerogative power going on there, and I thought, oh, maybe he's just making that decision because he thinks he can. And I did look for it, but I just couldn't find anything relating to it, and I might have missed it, of course. But yeah, I certainly couldn't find anything.
I suspect you haven't missed it. I suspect that the reason you couldn't find anything along those lines is because this is the kind of decision which is not of a justiciable kind, in the sense that the minister is not required to make decisions about whether to release reports commissioned about the way that our extraterritorial... Sorry, someone's got their speaker still on that's causing a bit of echo. It's not the kind of decision that requires a legislative power to make. It's taking, for ease, let me give you a rather extreme example. Would the Minister for Immigration require a power from in the Migration Act to decide whether or not he could call the Prime Minister to talk to the Prime Minister about our policies, our migration and refugee policies? Would that be the sort of thing you would expect there to be a legislative power for? No, of course not. That's why I've used such an extreme example. And this problem is not so obvious. It's very much more subtle, but it's trying to get at, I think, the nature of the decision making which is going on. So, of course, the Minister for Immigration doesn't need a power to decide that he's going to speak to the Prime Minister or present a particular report to Cabinet. And in the same vein, the Minister probably doesn't need a power to decide whether to commission a report and whether or not to release that report. We will deal with the question that somebody raised a few minutes ago about the Freedom of Information Act, which is now variously referred to in other states. Well, yeah, all the states and the federal government have a Freedom of Information type act. In New South Wales it's now called the Government Information Privacy and Protection Act. But we will deal with that a bit later in the course about standing of members of the community or our society to gain access to information of an administrative nature, and the way that we would petition to get access to the sorts of reports that Problem 7 is dealing with is through that mechanism, rather than through the Migration Act, which has a very different purpose. So I hope that's answered the question. Jump in if it hasn't, Robin.
Yeah, sorry, that's good. Thanks, Brett.
It's 8:05, but why don't we do, for those of you who are still here, why don't we do one more question? Anyone want to put forward 8, 9, or 10? Robin says bond. Peter says 8. What's bond?
Sorry, I'm just having a look at the question numbers. I think it was the last question regarding Australian Broadcasting Tribunal and bond.
Okay, I'll come to that one in a minute. I'm going a bit soft here. We'll do 2 more problem questions, but very, very quickly, because Peter's suggested number 8, which he tried. This is a question that is asking you basically whether you can seek judicial review of a decision by a minister not to make a payment which would appear to be payable under a contract. I'm just having a look at your response, Peter. Remind me how you've answered it. Does anyone, let me put it a different way, does anyone think that...
Sorry, I was pressing all the wrong buttons. Yeah, I've just... Sorry, Brett.
Sorry, go on.
I've just pulled the answer out, and I felt as though it's a fake act, isn't it, for a start? The fast-track stimulus act?
Oh yeah, it's not a lot of these are not, yeah.
Yeah, good. Okay, I thought it was. I tried looking it up, but it didn't exist. So the minister has claimed in the answer, or the question, I mean, the refusal to pay was a breach of contract. It didn't say why, but you know that was the first clue. So then I looked up some similar cases where in the textbook they talked about contract issues or issues akin to contract-like situations, as in I think it was Tang and Burns, the 2 university cases, and looked at some of the decisions there and basically just cited those because it seemed to make sense that the force of law, the legal effect, was based on a breach of contract or contractual issues as the founding form of law, rather than an administrative issue or a decision based on an executive decision. So then it was not justiciable by the ADJR.
This is a, I'll skip to it rather than facilitate too much discussion. This is a question, remember last week I said understanding administrative law includes understanding what it's not. This is a question which wants you to identify 2 things really. A, that by virtue of the Fast Track Infrastructure Stimulus Act, somebody's got their speaker on and we're echoing. By virtue of the Fast Track Infrastructure Stimulus Act, the minister had a power to enter into an infrastructure project. So there was a power to engage the Stellar Innovations company to build infrastructure. That's the administrative aspect of this particular problem question. Then what it goes on to say is that pursuant to that power, the minister enters into a contract, and that a dispute arises about whether or not that contract is performed such that the minister withholds payment. The short answer is that it's asking to identify that the power to enter into a contract is present, so there was no doubt that the contract could be lawfully formed. But then what happens is a contractual dispute arises, so there's a disputation about whether or not there was performance by Stellar Innovations giving rise to a legal obligation on behalf of the government to pay Stellar Innovations for the work. So the second part of the problem is to identify that it's a contractual dispute. So the question, that's right, John says, so really it's a question of contract law. In essence, there are two parts. The first part requires you to identify that there was a power to enter into this contract to build projects. It wasn't the minister purporting to build infrastructure in Taiwan, which would probably be ultra vires if the Infrastructure Stimulus Act was concerned with building infrastructure in Australia. The second part of the question about whether or not you could seek judicial review of a decision not to pay the contract arises under the ADJR Act. The answer is that it doesn't. That's not the sort of decision that, when you have a look at the ADJR Act, is reviewable as an administrative decision. The remedy here, I think, you will find is one of contract law. So you'd be, if you were Stellar Innovations, let's say you're giving your advice to Stellar Innovations, you'd be probably saying to them, your remedy here is in contract law, that is, it is you need to sue for payment, and basically the dispute will become one of whether or not Stellar Innovations performed there, and giving rise to a legal requirement on behalf of the minister to perform his end of the bargain so struck by paying for the work done. Peter, you've got some sort of red hand coming up. I'm not sure if that's the internet equivalent of...
Yes, Brett. It's just, I did think there could be a side issue, which was, that's why I tried to look up the Act, because there could have been something under the Act which maintains that the minister had to give some kind of notice or give some kind of reason without having access to the Act, because it's a hypothetical Act. It may turn out it was reviewable because of the procedures. If he had to do something according to an Act regarding the termination of contracts in breach and the communications of the decisions to those parties within certain times, stating reasons and so on.
And so what's the question there?
That if because there wasn't an actual Act to look up, then I thought it was a contract law dispute. But if it was a real Act that there was, the availability to look up, then there may have been a dispute under the ADJR if the minister was required under an Act to make certain reasons or communications within certain times to a contracting party that they had a dispute with.
Look, that's, as a matter of basic principle, probably a very good way to analyse the problem. So, well, it's Peter, isn't it?
Yes.
So what Peter's saying there, I think, is, correct me if I'm wrong, Peter, if this Act, this infrastructure legislation, included a requirement that a minister who receives an invoice for payment for services rendered must then pay the invoice, potentially you might, and that a decision made under such a clause is reviewable under the ADJR Act, then you might have a basis for administrative review of some kind. As a matter of basic principle, I think that's a good way to be thinking about this particular problem. In practice, the reality is that governments contract with private parties all the time, and the question is, A, do they have a power to enter into contracts in the first instance, and if they do, the law tends to leave any questions of disputation about performance and payments under particular contracts to contract law. Any questions arising out of that? Has that answered the issue you raised, Peter? Peter, you've given me two responses there, it seems, no and yes. I'll take yes as the answer, since it was the last.
Are there any more questions? No. And am I happy with the response? Yes.
Okay, good. My bad. That's what we call in my profession a double-barreled question. You'd all object if I was asking double-barreled questions because you wouldn't be sure what you were getting an answer to. So you can tell it's getting late in the day for me. We'll go finally to problem question 10 if you want to. The numbers are now dwindling. I've only got those of you who I can see regularly making contributions online now, so the same names are popping up, I'm noticing. Question 10, problem question 10, who wants to lead off? I think, Robin, that was one you wanted to raise.
Yeah, the reason I actually asked it because I'm being a bit lazy, if I want to be honest. I did look at the question and then I started to read the case and I just went, I just don't have the time right now to do it, and I just thought if I can get you to explain it and then I can go back and actually do it for myself would be great. If you don't want to, don't do it.
Well, the problem question number 10 really asks you to make an assessment of how the High Court arrived at a decision that the Australian Broadcasting Tribunal concluded that, sorry, the ABT's conclusion that Bond wasn't fit and proper was not reviewable. I think that's probably what I will do is leave you to have a look at the decision, although I note that John has made a very good contribution. Have you had a look at that, Robin?
No, not yet. When I first looked at it, no one had answered, so I'll go back and have a look at John's response and I'll work it from there.
Yeah, it sounds like everybody wants to be in John's study group because he's making a pretty solid contribution to all of these questions, and for the most part he's approaching it in a fairly structured way. So I encourage you all to have a look at those and certainly engage with them. Engage with John on these observations he's making, because it will be, I think, of tremendous benefit to you all come exam time. All right, well, it's 20 past 8. Are there any final issues? A definition of substantive. If you're asking generally what a substantive decision is, Gordon, a substantive decision is a reference to a what is essentially the hub of a dispute. So in any given litigation, whether it be of an administrative nature or a commercial nature or a criminal nature, you will have what we often refer to in the law as interlocutory decisions. Interlocutory decisions tend to be those ones which are made of a procedural nature, in the sense that they don't determine the dispute in any final way, but have some impact on how the dispute will be resolved. So decisions about whether evidence needs to be exchanged, whether or not one party has a right to discovery, well, there's no right to discovery, whether one party should have discovery, those sorts of things. A substantive decision is one that decides it. So a substantive decision is one which says no, you cannot have the relief you're seeking because you have no standing to bring these proceedings, so your petition for judicial review is dismissed, or in the case of Holly and Everett, the substantive decision there at first instance was that the respondent had to pay $990 to the applicant. On appeal, the substantive decision was that there had been some degree of error and that the decision had to be remade again. Does that answer your question, Gordon? For present purposes, you can assume that final and substantive, if they were found together, would be perhaps a degree of redundant language. I don't want you to be so rigid in your thinking as to form a conclusion at this early stage of your studies that final and substantive always mean the same thing, and I'll give you one example of why in a different context. In a criminal context, for example, a substantive decision might be a decision by a magistrate or a judge sitting alone, or even a jury, that a person is guilty. It's not, though, the final order in the sense that it doesn't completely dispose of the proceedings, because then what you have to do is move to sentencing. And it's not until sentencing is imposed that you have, at least at first instance, a final decision. And even then, you may not necessarily want to use the word final, because there are appeals which come into place. A final decision might perhaps be a decision by the High Court in a appeal from the Federal Court concerning a decision about whether or not a delegate for the Minister of Immigration has correctly applied the Migration Act, and whether or not, for instance, you'll recall the various disputes that were going on during the turbulent years of the Gillard and Rudd governments surrounding the Malaysia solution and the attempts to make reforms to our migration system. You would find a degree of finality in some of the High Court's decisions, but sometimes the final decision follows a substantive decision. But I don't want you to get too drawn on those sorts of technicalities. They're simply not important at this level. All right, unless there's anything final, we'll wrap up. We'll continue, as always, on the discussion forums. If anyone's needed anything, go have a look at those emails I've sent out about how those discussions are progressing. I can see already that there are a number of you who are very enthusiastic about this course, which is absolutely fantastic for your own purposes, that is, because if you are all engaging in a high quality way on those discussion forums, you'll have no difficulty getting through this program, I would have thought. All right, everyone, have a good night, some dinner, and we'll see you next week.